Before this courtroom session even begins, you can already sense that this is not going to be your typical orderly legal proceeding. We're diving into a landlord-tenant dispute that has been dragging on for months. But what makes this case stand out isn't just the legal complexity. It's the behavior of the people involved. We've got Golden Pond Estates trying to evict tenants over alleged misconduct, specifically pointing the finger at Travis Miller. But here's where things get messy. Procedural confusion, missed deadlines, questions about jury trial rights, and even conflicting interests between the two defendants themselves. That alone is enough to complicate any case. But then you add courtroom conduct that raises eyebrows from the very first seconds. And trust me, the judge notices everything. This case quickly becomes less about just eviction and more about credibility, respect for the legal system, and whether the defendants are helping or hurting their own position. So here's the big question as we step into this. Is this truly a case of unfair eviction, or are the tenants sabotaging themselves in real time? Let's watch closely, because the smallest moments here might end up carrying the biggest consequences.
Ms. Bailey and Mr. Millerans, would you join us, please?
Yes, Your Honor, we're present.
All right, Mr. Millerans there as well?
Yes, Your Honor.
Oh, boy. Mr. Millerans? Would you get up and put on a shirt?
Yeah. Yes, Your Honor. I'm actually trying to find a shirt right now as we speak, Your Honor. Sorry about that.
This is a trial. Boy, I can tell you have great respect for the process. All right. The title of this case is Golden Pond Estates versus Travis Millerans and Randy Bailey. They wish to terminate their tenancy primarily because of the misconduct of Travis Millerans, who shows up for court without a shirt.
Right away, the judge frames the entire case, and notice how quickly the tone shifts from procedural to personal. The eviction isn't just about unpaid rent or lease violations. It's being driven by conduct, and in landlord-tenant law, that's a major distinction when misconduct becomes the basis for eviction. The court isn't just evaluating contracts, it's evaluating behavior, credibility, and whether the tenant is disrupting the property or violating community standards. And here's the key detail. The judge immediately calls out Travis Miller's courtroom behavior as an example. Showing up shirtless to a trial? That's not just inappropriate. It signals to the court a lack of seriousness, which can absolutely influence how arguments are received moving forward. Now think about this. If a judge is already questioning your respect for the process in the first minute, how much harder does it become to win your case? Because in court, perception matters just as much as facts.
Mr. Steve Cromendike is here on behalf of Golden Pond Estates. We've been tussling with this case since early December. Randy Bailey is present, and Meg Bauer is here from Legal Aid. Theoretically, this matter was set for a trial today on a termination of tenancy. Mr. Millerans and Ms. Bailey wanted a jury trial, and they don't have the wherewithal to conduct a jury trial. They didn't file the information in a timely manner. I didn't set the matter for a jury trial.
Wait, Judge, I'm sorry. Did they not file in a timely manner?
I can't remember. Maybe I'll take a look. Maybe they did. So you're contending there's a jury demand in here?
Yes, my understanding is that they filed a jury demand within the 5 days of the first hearing and paid the jury demand fee or had it waived.
I'm not sure that's accurate, but all right, let's assume for the sake of argument it is. I set this for today. All their witness and exhibit lists were due by January the 9th, which they filed on January 28th.
I don't believe the plaintiff filed a witness or exhibit list in this matter.
No, they didn't either.
Exhibit.
So plaintiff filed a motion for summary disposition that the defendant has not had an opportunity to answer, and they amended the complaint that the defendant has not had an opportunity to answer.
This is where things take a more technical but crucial legal turn. We're now dealing with conflicting interests between defendants, and that's a serious issue. The attorney from legal aid is being cautious here, and rightly so. Representing two clients in the same case is only possible if their interests are aligned, and clearly, they're not. Why? Because the eviction of Randy Bailey is allegedly tied to the behavior of Travis Miller. That creates a legal conflict. Defending one could mean blaming the other. This is exactly why the attorney chooses to represent only Bailey. From a legal standpoint, this is about ethical obligations. Lawyers cannot represent clients whose defenses could undermine each other. That would violate professional conduct rules. So, here's something to consider. If your own co-defendant is the reason you might lose your home, do you stand by them or distance yourself to protect your case? Because that's the dilemma unfolding right here.
So if I understand correctly, Ms. Bauer, you'll be representing only Randy Bailey?
Randy Bailey is the listed client in our system. If the court would prefer that I make my appearance on behalf of both defendants, I can do that. And I am primarily motivated to be involved in this case based on the procedural confusion.
Well, one problem is Randy Bailey and Travis Millerans they have conflicting interests. The primary reason they want to evict Ms. Bailey is because of the conduct of Mr. Millerans.
You have articulated my apprehension about appearing on behalf of both defendants.
All right, why don't you go ahead and place your appearance on the record as who you're appearing for?
Thank you, Your Honor. Attorney Meg Bauer, P84816, appearing on behalf of Randy Bailey.
All right.
Your Honor,
Yes,
if I may, Meg and I talked for quite a bit yesterday afternoon, Meg, about a potential conditional dismissal here and what terms of that would look like. I have not been able to follow up with you until now about it. You said you were going to talk to your client, which I suppose is just Randy at that point, at this point. But in any event, has there been any progress on that?
well, I'm glad that Meg is here. These people could use some help. They claim that they had legal knowledge, which they don't, and that you guys can discuss this matter in a rational manner. And nobody wanted to be here today. I appreciate, Mr. Commandant, you were going to have to drive down here from Holland, and everybody would have to be here. So on short notice, I turned this into a Zoom hearing. Ms. Bauer, do you think there'd be any merit to you either discussing it further with Mr. Commandant or with Ms. Bailey in a breakout room?
I did speak extensively with the tenants last night, and I thought that Attorney Cromendike also needed to speak with his client. So I have a little bit of an understanding of the range of possible settlements based on my conversations. I am hopeful that something is possible.
I've talked to my client, and I believe he's on board.
All right. How about if I put Ms. Bailey, I'll put you in the waiting room. Don't go away. Meanwhile, Mr. Millerans can get pants and a shirt. And I'll put the two of you in a breakout room and see if you can get the details of the conditional dismissal.
Now we're seeing a shift away from
And,
confrontation
maybe we
and towards
can
something courts
have
actually
some good
prefer,
result
settlement.
here
Both
today.
sides are discussing a conditional dismissal, which essentially means resolve the dispute under agreed terms, and the case goes away without a full trial. This is extremely common in landlord-tenant disputes. Trials are time-consuming, expensive, and unpredictable. So if both parties can negotiate terms, like payment plans, behavioral agreements, or move-out timelines, it's often the best outcome. But notice the language. We're close, but not quite there. That tells us negotiations are fragile. One disagreement could send this straight back into litigation. And here's the strategic angle. Is settlement a fair compromise here? Or is one side being pressured because they don't have the resources to fight a full trial? Because in many cases like this, Power imbalance plays a huge role behind
Here
the
today.
scenes.
And Judge, I made it clear to Ms. Bailey that I was going to articulate this to you. But my presence here is primarily in service to the court. Obviously, I have an ethical obligation and legal duty, but
Well, I've already said, I appreciate your being here, and you all very often help resolve difficult cases, and I do appreciate that. All right, I'm going to put both of you in a breakout room. I'm going to sit here and think deep thoughts for a while, or maybe not so deep thoughts. What's our current status?
thank you, Your Honor. Attorney Cromendike and I have had extensive conversation about the range of settlement terms. And although we're close, we've got a few details to massage out still. So for that reason, we'd like to ask the court to schedule us to keep us on track, that perhaps we have the court schedule a pretrial, perhaps a deadline for witnesses and exhibits in a couple of weeks. And we were discussing that ideally the week of February 16th, but obviously depending on the court schedule, with the hope that we'll have a settlement that we can have executed and entered at that hearing, but understanding that that's a turning point to keep us on track.
All right, the clerk did bring in the jury demand. It was in the file. I couldn't find it. It was filed within 5 days of the original hearing on December 5th, and the defendant did pay the $50 jury demand fee. So theoretically, this case would be set for jury trial. There are a couple concerns. I don't think there's currently any valid lease in effect. Do you agree with that, Mr. Commondike?
I do.
We've been tussling with this, as I said, since December. Will be December, January, and February. There is no escrow order in place. Is a plaintiff requesting one?
We're not, and frankly, there hasn't been an issue with payment of rent.
And Ms. Bailey, we've discussed the portal being unlocked.
All right.
Thank you.
All right. Let's look at February 16th.
And
That might be President's Day.
and my thoughts were that we don't bog your schedule down with a day blocked out for a trial at this point. Because if it's not necessary, we keep the date open for the court.
February 16th is a holiday. I normally try to be gone during that holiday, but I'm not.
I think
Let's look at February 13th.
I think
13th, I'm going to be out of town.
All right.
Steve, are you okay with the 20th? I know that's typically the landlord-tenant days are Mondays and Fridays.
20th would work.
I have an important appointment at Sunset Key, which used to be called Beer Can Island, on February the 20th.
My
So
apologies,
let's
Judge. I
look.
wouldn't want to interfere with that.
I've got to go buggy unless I get out of here again. What is this? That takes us all the way, I apologize, to February 27th. Friday,
27th
February
would work
20th.
for me.
All right. At 11 o'clock. It's going to be problematic because I'm missing so many Mondays and Fridays in February. The days are going to be kind of dense, but I think I may be able to put some things in the afternoon of that day. So we'll block out 1 hour on Friday, February 27th at 11 to 12 for status conference. If the matter is resolved before that time, you certainly can file a conditional order of dismissal at any time. Miss Bailey, Miss Bauer has filed a verbal appearance, and she'll file a written appearance on your behalf, and you've been discussing things at length. Mr. Millerans, my advice to you is that you continue to keep things on a low profile. There are a number of things that you are alleged to have done, which is why they want to terminate your tenancy. So
Your
my
Honor.
advice,
Don't interrupt.
but I don't, we haven't got to that issue. They're accusations. So just don't bring up any more accusations.
This moment is
Uh,
subtle, but legally very important. The judge advises Travis Miller to keep a low profile and avoid further disturbances. That's not just casual advice, it's a warning. Why? Because in cases based on misconduct, ongoing behavior can actively strengthen the landlord's case. Every new complaint, every incident, every violation, it all builds a narrative. And here's the critical part. The judge even stops Miller from bringing up accusations prematurely. That tells us the court is trying to keep things controlled and focused. But also that there may already be a history of conflict. Then we get into the rent issue. And this is where many viewers get confused. Even though the tenant couldn't pay rent due to being locked out of the portal, the court explains something key. In eviction cases, landlords sometimes cannot accept rent once termination proceedings begin, because accepting it could weaken their case. So now ask yourself, how do you defend yourself when the system itself limits your ability to fix the situation? That's the tension building here.
I don't want any more disturbance or discord out there. That'll just make their case easier. All right. Parties did work at resolution, weren't unable to get there.
Yeah, that's a question.
I'm allowed to speak.
Yes.
It's actually for Mr. Cromendike. Because I was locked out, of the portal, can the $50 late fee that was put there for January's rent be removed? Because Casey did
Well,
ask
we
for
can
the rent.
discuss that later. Right now, you can't pay your rent. In a termination of tenancy case, they can't accept your rent.
But
So
they're
they can't say
asking
we
We're
won't
not gonna-
accept your rent, then give you a late fee. So you can discuss that with Ms. Bauer.
Yeah.
But certainly keep stockpiling the money if there's an issue regarding rent.
Judge, we're not going to raise a Park Forest waiver argument at this point, but we'd much prefer to have the rent paid.
All right, then you guys can discuss that. Defendant will allow rent to be paid. It's interesting. It makes sense. What happens is people don't pay the rent and they don't set the money aside. They spend it on car insurance or groceries or lottery tickets or whatever. And then when it comes time to pay the rent, the money's gone. So there is certainly logic in continuing to pay the rent. We don't have an escrow order. And that way the rent will not be an issue. So I guess I can accept that. All right, this matter's continued all the way till Friday, February 27th, which is about a month from now at 11 o'clock. If the matter is resolved, that's fine. If it isn't resolved, we'll set a jury trial date at that time. All right, we will have a finalization of any witness and exhibit list by that time. Mr. Cromendike, any further?
Nothing.
All right, I'll see you guys in February or sooner if you do work out a resolution.
Ms. Bailey, I will
All
give
right,
you a
Ms.
call.
Bailey. My advice
Your
is you
Honor.
stay in contact with your lawyer.
Yes, thank you, Your Honor. Thank you, Meg, and thank you,
All right.
Mr. Cromendike.
All right, Mr. Millerant, you as well. Thank you both.
Yeah.
Thank you,
Thank
Judge,
you.
for the time. Steve?
So let's step back and look at the bigger picture. This case wasn't resolved today, but what we witnessed was a courtroom balancing act between legal procedure, human behavior, and strategic negotiation. Golden Pond Estates is pushing for eviction based on misconduct. The defense is navigating procedural confusion, late filings, and internal conflict between defendants. Meanwhile, the judge is clearly trying to steer both sides toward resolution, while also warning that continued behavior could tip the scales decisively. We also saw critical legal principles at play: the importance of courtroom conduct, ethical limits on legal representation, the strategic role of settlement negotiations, and the complexities of rent handling during eviction proceedings. Now, everything hinges on what happens next, whether they reach a settlement or this escalates into a full jury trial. And here's the question we leave you with. Do you think this case is about legal technicalities or personal accountability? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.